Broadcast is now starting. All attendees are in listen-only mode.
Hello, everybody. This is Gail Pendleton, Executive Director of ASISTA, and with me today presenting, we have Flores Bachman, our Senior Legal Counsel, who focuses on member support. In the background, we are being helped by both Alam Musa and Maria Lazarino. So if you encounter any kind of logistical problems with this, please put a note in the chat box. I think, is that the right place, Alam and Maria? I think so. And let them know, and they can work with you to fix them. Alam, you could move to the next slide. The goals of this webinar are that once you've been through this, you should be able to apply best practices for how you respond to requests for evidence, notices of intent to deny, notices of intent to revoke, with some ideas on how to avoid those problems if possible ahead of time. Some exploration of what we think the best practices are right now for filing appeals with the Administrative Appeals Office, and generally updating you on the latest challenges that we're contemplating to the various onslaught of U.S. policies and practices that are undermining survivor safety. It's a lot to get through, so we may cruise through the end if some of you aren't encountering some of these issues yet, and we'll come back to it as the problems continue. Now, before I turn this over to Laura, I've been asked to share with you are you thankful for ASISTA campaign, which you can see here. And it occurred to me that we should do this because I came from a conference last week where some of you are at, and I realized I am so thankful to be part of a community of like-minded advocates. I basically think of us all as social justice warriors, warriors for peace. And without this community, I would be completely emotionally exhausted. So I want to thank all of you for the work you do. And I'm hoping that as you go into Thanksgiving, you can think about how you are thankful to us and maybe make an extra donation for us to help us keep all this great staff that we have going and add a litigator coordinator. Okay, next slide, please. Laura?
So, hi, everyone. We're going to just get right into it. We're going to start with the new RFE NOID guidance. So, as you know, on July 13th, USCIS issued the new guidance, which went into effect September 11th, and which replaced their memo from 2013, okay? In this RFE NOID guidance, basically adjudicators have full discretion to deny an application without having to issue an RFE or notice of intent to deny. And the instances where they can do that is lack of sufficient initial evidence, meaning mostly applications with no supporting evidence. And where we have seen this is basically applications being submitted as placeholders. So you're coming up on a deadline or an age out or an LEA certification that's expiring, and you just go ahead and submit in order to overcome that particular deadline, but you don't have all the evidence you need. So that's not going to fly anymore. Additionally, it allows full discretion to deny when applicants have no basis for the benefits sought, which was always the case. That regulation had always been there, but I think this just solidifies that that's going to be happening. In other words, they're not going to do a full review and let you know that they're doing it. They're just going to go ahead and do it if the person wasn't eligible. And the family-based petition is the easiest one, where they can present an example. So filing an I-130 for a grandmother. Obviously, a grandmother is not a qualified member in a preference category, so not eligible. Next slide. Okay, so the rationale of the new guidance is they want to prevent frivolous applications and placeholder applications, like I mentioned. If you heard any of the stakeholder meeting Q&A on this, I mean, their focus really is on quote unquote fraud. But how widely they're going to be, or how extensively they're going to be claiming that things are frivolous or placeholder or fraudulent, We don't fully yet know, since this was just implemented on September 11th, but this is what's going to be coming down the pike. So it's not intended to penalize for innocent mistakes or for misunderstanding of evidentiary requirements. And again, the FAQs have some examples that seem pretty innocent and like they're going to be giving you the benefit of the doubt. Unfortunately, we don't know what those hoops are that we're going to have to jump through in order to show they were in fact innocent mistakes. One practice pointer I will give here, though, is if there was an innocent mistake made by your office, we all know that this happens, clerical errors, accidentally sending it to, or accidentally including one piece of information but not another, and it literally just got left on the copier or something to that effect. Or a date was put in incorrectly, either by you or by your legal assistant. I mean, those things happen. Fall on your sword. Let them know it wasn't an innocent mistake, and not only that, it was made by you and not your client. And I know many of you already do that, but it's worth repeating since this new guidance is going into effect. Guidance doesn't apply to DACA or asylum because there's other guidance on those too. Next slide. Next slide. Oh, there we go. Okay, so other practice pointers, always read the instructions, check the statute and the regs. And actually, I'll say in the opposite order. Start with the statute, then the regs, then the instructions, because sometimes you'll find maybe the instructions aren't following their own regs or aren't following the statute. Especially when you get into the very long instructions, like on an I-485, and we all know that the regulations of U's or T's are super specific, and we want to make sure that the instructions follow those super specific regulations of the U's and the T's. So start with the statute, then the regulations, then the instructions, but always review them all. And then, of course, review the checklist, only because that's what USCIS officers are going to be reviewing in order to determine whether there's quote unquote initial evidence. And again, initial evidence really is spelled out in the regs, but it's kind of like their checklists are meant to be a shorthand. Unfortunately, it might just be too much of a shorthand. So review the checklists as well, but they don't supplant the instructions, regs, or statutes. And down below, you'll see just an example of what the I-360 checklist looks like, right? And this is just part of it. I just took a little screenshot of it. But you see, it's just kind of it should mirror the regulations, but it goes kind of through the list. And sometimes it probably asks for more than you're necessarily going to need, because of course we know the standard for review is a little bit different for survivors. And so we want to make sure that checklist isn't asking for too much. Next slide.
Wait, Laura, before you move on,
Sorry.
while I was figuring out this slide thing, someone asked, and I assume this is relevant to what you were saying, are you saying to reach out affirmatively as soon as we realize a mistake? And did you mean reach out to us or reach out to someone else?
Actually, that's a good point. I think reach out to us for sure, because if we can get with Vermont, get with headquarters, ombudsman, whoever, and everyone and anyone who's going to listen to us to make sure that gets changed. So yeah, if you see that, as soon as you see it, let us know, and we'll talk through, is there a discrepancy? And if so, how does it affect our survivors specifically? And then that'll help us to be able to articulate that and get the changes made at headquarters.
Helene, we're going to come back to your adjustment question later on. So if we forget to address it, please raise it again later. And just to piggyback on what Laura was saying, and you'll hear me say this a lot, we'd much rather hear about your problems sooner rather than later, not only to help you address them sooner, but it also helps us identify trends that are happening and figure out responses to them.
Absolutely. Yeah, that's so important, because a lot of what we're going to be discussing just even in this webinar our discussions and our research start from what we are having you tell us and what you're already seeing on the ground. So yeah, definitely let us know as soon as possible. Okay, next slide, and I think that's you, Gail. Oh, sorry, preparing the application. Prior slide along.
No, I think this next one's mine. Okay. And then maybe Laura, while I'm doing this, there are a couple questions that are following up on what you said. So why don't you take care of those? Okay. So this is an example, and we're going to have you vote, and then we're going to have a conversation. So your client is a survivor of domestic violence with a signed law enforcement certification, and she has a son who will turn 21 in December 2018. Issue spotting. She remembers speaking to an immigration official when she crossed the border, but doesn't remember what else happened. How would you file the U visa? Let's do the next slide with the poll. So how does this poll work? Are people going to be able to actually vote here?
No, actually, they can. The best way to do it is just put it in the chat box so that you and I, Gail, can take a look and see what people think. Is it A, B, C, or D?
Okay, and I think we do have polling technology that we can apply next time. But anyway, so here are your options. You file the standalone 918 without an I-192. I'll read them and then we can go back to the facts so you can figure out what your answer is. You file the 918 with the I-192 about inadmissibility, saying that you may need to be amending later on inadmissibility. You file the 918 with the I-982, assuming the worst case scenario, which I assume means identifying every possible ground of admissibility you think might apply. Or you wait until you have further information. So let's go back to the next slide so they can review the facts while they figure out what their answer is. Right. So this is really bottom line. How perfect does your inadmissibility waiver application have to be when you decide to file? And what are the issues I think we're going to get into for why you may decide to file sooner rather than later?
So mostly right now we're seeing a lot of D's, a lot of B's, a lot of B's or D's. And let's see, we saw a couple of C's.
Okay. All right.
Yes, so it looks like we're split between B's and D's.
Okay, so let's go back to the votes. So that's between that you're going to file now and say you're going to supplement, or wait until you file until you have all the information. Now, what was the fact, Laura, that makes you think you don't want to wait? If that might be an issue.
So let's go back.
Let's go back to the facts again.
So the main fact of why you don't want to wait is that your son's turning 21. So you want to get that filed because of that. And the LEA certification is already signed. So you've got that deadline. Right.
So you've got those kind of inherent deadlines, right? And just remember that there is a fix to aging out, but it's measured. You basically freeze the time of the derivative at the time the principal files.
Correct. So if we're looking at December of 2018, the son turning 21, then we want to file by then, right?
Right. You got to get it. And I would not wait till the last minute on any of this stuff.
No. Absolutely not, especially if we're doing fee waivers, which I know was a separate webinar that we already covered, but I think many of you have reached out to us on fee waiver denial issues. And so anyway, you don't want to wait till the last minute.
Okay, and now let's go back to the other options, because I think probably any of the other three are okay. I do think my view, and people may differ, is that if you know you've got inadmissibility issues, you might as well flag that now and say you're going to supplement.
Right.
My concern with C, just based on experience, is it depends on what you mean by kitchen sink. Do you mind if I make a couple points, Laura?
Sure, go ahead.
Okay, so I am the person who has told you in the past that you should ask for the kitchen sink, using the words like, if we have missed any grounds of inadmissibility, please waive them for the same reasons we're asking for the other grounds to be waived. And I was wrong to tell you to do that, because I was wrong in thinking that they would figure out what the grounds of inadmissibility were based on your facts. So that's one thing. You've got to specifically designate the grounds that you know apply. The other thing that I am calling a paradigm shift is that in the past, one of the paradigms I suggested was fess up and ask for mercy. We can't do that anymore. We're now back to being your typical lawyer, which is basically we are squirrely about revealing things that don't have to be technically revealed because that's going to be in the record down the line. And these cases are taking a long time. And it's not clear at this point who's going to actually be looking at them. So we're back to the paradigm that you probably learned when you were a lawyer, when you started learning how to be a lawyer, which is you only answer the questions you're asked. You have to answer them truthfully, but you don't have to supply other information unless it's asked. So that would be my problem with C, kind of depending on what you mean by kitchen sink.
Yeah, and the only thing I was going to say in terms of A, which I think no one gave us A, I don't think, and that's good because of obviously the memo, and I-192 will be considered initial evidence if it's required, and given the scenario, it will be required. And then in terms of D, wait until you have all the information. Sometimes that's just not possible, right? Especially if you want to try and do a FOIA or if you want to get fingerprint background checks. It's a case-by-case decision, honestly, but I can't say that across the board, D is always going to be the best answer. I think it's just a risk assessment case-by-case, whether you have enough information to file.
Okay, I think you're taking over now.
Oh, cool. Next slide. Okay, so practice pointers, which again, instructions, guidance, application, right? Be aware of your deadlines, 2 years. For VAWA, you've got your 2 years post-divorce, or if there were, death of the petitioner, death of the abuser, or loss of status of the abuser, right? And then you also have the birthdays of derivatives. U as in T's, cert expiring, not necessarily required for the T. And also birthdays of derivatives like we had in that scenario. The other thing to consider, which we know just went into effect yesterday, so the NTA memo now is applying to VAWAs, U's, and T's as of November 19th. And because of that, anytime you're doing this risk assessment on when to file, how quickly to file, what kind of evidence do you have at the time of filing, you're going to have to also talk about what the potential outcomes are, right? Is it enough to get you an RFE NOID, or are you going to get a denial without an RFE NOID? And what does that lead to? When will when can an NTA be issued? Later on, we'll discuss briefly the NTA, but additionally, there's going to be another webinar next week on the effects of the NTA memo on survivors. So we won't get into it too much, but I put it in there because for case management purposes, for purposes of your client contract, you're going to want to look at what kind of advisals you want to put into place now before you file the case, and what kind of conversations you want to have with your client to make sure that they're well aware of what filing now means. Okay, next slide. Okay, turning it over to Gail.
Okay, great. So let me just preliminarily apologize to those of you who've heard this kind of training before, because some of this is going to be review, but I think we've got a lot of new people. So we're going to be reviewing some practice pointers we've had for a long time. Next slide, please. These are based on our experience of the kinds of RFEs that we have seen over the years. Typical is a boilerplate RFE, which looks like they basically cut and pasted some standard reply when you have to people who have supplied no evidence. It's a list of all the evidence you should supply. The heads of the unit have repeatedly said that should not be happening and indicates a training issue. And we still are able to send emails to the heads of the unit. I think they would pay attention to this. They can't reply to us, but it does seem that sometimes magic happens when we send these things to them, so it's still worth us our doing it. And the other thing they have said, and is in the what's the AFM stand for?
Foreign Affairs Manual.
Okay, why isn't it FAM? That's what I want to know. But anyway, this is a really good site because the
I'm sorry. Sorry about that. You're saying AFM. Sorry. It's the Adjudicator's Field Manual.
Oh, perfect. Okay,
that makes more sense.
Yeah, and this is actually a really useful site because if you look at their own kind of basic regulations on what they have to tell you, it says that we have to tell you why we're denying. This is what the heads of the unit have said repeatedly over the past 20 years, that that's not enough, because we've said, but that doesn't tell us that there's no notice on how to respond. And they said, yes, that's true. We have to tell you what's lacking specifically, why what you submitted doesn't meet the standard or the burden, tell you what evidence they need to adjudicate the claim. And you're more likely to get some of that, less likely to get the explanations on why what you supplied isn't good enough. And they often give you like a list that frankly is primary evidence of other kinds of evidence that complies. So if you're getting anything that doesn't have that in, immediately contact us, because this is my practice pointer for you on this is the don't kill yourself replying practice pointer. This is their fault. This is their problem. You should not have to bend over backwards to recreate what you've already done. We'll get into a little later on how some easy things you can do with what you've already submitted to make it clearer for them. But if you sent this to me, I would immediately send it to the heads of the unit and say, this is a problem. You need to fix it. I'm going to tell them to reply and just say, read what I filed, basically.
And that's one really important point, Gail, is that, yes, contact us, but reply anyway.
Yes, we'll always tell you to reply timely, because I don't think we have a slide on this. Those of you who are old hands may have in the past been able to fix things through the hotline. So from what I can see, the hotline isn't even responding most of the time anymore, and they're definitely not fixing things. And procedurally, the hotline is not a formal response, right? And nowadays, you want to be meeting all deadlines, if possible, ahead of time and formally in writing, so you don't give them any wiggle room to deny your cases for purely procedural reasons. And Laura, you'll take a look at these questions that are coming up, so I won't be distracted, right?
Yeah, I'm looking at the questions right now just to see if we haven't answered them as part of our
Okay, and Laura's fairly new to the system, so just one practice pointer, Laura, is if you think the question and answer is worth everyone seeing, send it to all, not just privately. Okay.
Will do. Yep.
Okay, so Alam, let's move to the next slide. All right, again, you've already submitted these documents. They're literally asking you for documents you already submitted. I'd love to see a show of hands, kidding, of how many people have had this. Don't kill you. This is another don't kill yourself. Contact us, and let's move to the next slide, Alam. I think we're getting into how to present this stuff. Yeah, so again, many of you have heard this before. The vision I want you to bring up in your head is you're sitting in this massive bureaucratic building. You literally have an office that's like 4 feet by 4 feet, no real walls, just those horrible like nose height separators, and piles of files. Which one? And the first thing in the morning, you're drinking your coffee, you open one that's just a whole bunch of evidence with no guidance on how to follow it. The next one you open up has a roadmap cover letter, which leads you through. Really, if you were, you could just actually read the roadmap and look at your checklist and grant, and an index so you can double check. Which one are you going to do first? Which is going to be the one that's easy to do? So I know it's more work for you, but try to put yourself in the shoes of these people who are overwhelmed with cases. The roadmap cover letter is not a list of eligibility requirements and a statement that your client meets it. It's like literally bullet points is what I would do, because again, these aren't lawyers and you want to make it really readable. Is domestic, battery, extreme cruelty is economic control and degradation. See client's declaration at paragraphs 5, corroborating declaration from counselor at paragraphs 7 through 9. That would be one. That would be do that for each eligibility requirement, so that if you're the adjudicator, you're reading this, you got your little checklist, and then you go to the index of documents, which again I would organize by eligibility requirement. you can if you're using the same document, say for, you know, good faith marriage and residence together, you don't have to supply them twice. You can cross refer within. But I would, again, within there, I would do a little paragraph. I learned this when I was doing asylum in the 80s. I would do a little paragraph on why this document is showing what I say it shows and which parts of it you should read. And then I would literally go into the declarations and the police reports and whatever else is plotting and highlight the parts you want them to read. So that I'm the adjudicator, I read your cover letter, I look at my checklist, I look at the index, I look at the highlights, and I'm done. I know that you've supplied your case. So I know it's a lot of work, but I think the more work you do up front, the less likely you're going to get kickbacks. Or if you get kickbacks, the easier it is to reply to them saying, could you read the cover letter and the documents, and you'll show that we've proved our case. Another thing to really do up front, and I haven't seen a lot of this lately just because there's so much other stuff happening, but this is often what they'll seize on to deny in the past, now that they don't have these other easy ways to deny, which is going through the applications with a fine-tooth comb to find inconsistencies between dates and residences and what it says on a tax return versus what you said about, you know, where you were living, all that stuff. And they'll come back and literally pull apart every piece of evidence you have and argue that it's inconsistent, and therefore nothing that you say is credible. So the first challenge to that is, are the things that you're finding inconsistent, are they actually material to eligibility? A lot of the time they're not. Again, don't assume the adjudicators are going to understand what you mean by material, but you want to be saying that, so when you go to the heads of the unit or we go with you to the AAO, it'll be there in your record. And if it is material, this is where you need to do your homework up front if you can. I would, because we know, even if it isn't material, you could do a list for them we know there are the following discrepancies between what was filed for her as an I-130 and what we filed it as a 360, or there's a discrepancy between what the prior attorney filed in the original U visa application and what we're now supplementing in our I-192. We're telling you up front that we know about this. This is why they happened. This is why either they're not material, or if they are material, here's more evidence to show which of these answers is correct. The third thing that isn't in here, which I think will be later in terms of appellate arguments, is totality of the evidence, right? They're not supposed to, it's not whether you meet your burden of preponderance burden with each individual piece of evidence, is looking at all the evidence together. Have you met your preponderance burden? And we'll come back to that later. But you'll often see them saying, this piece isn't credible, and it doesn't meet the standard. This piece is incredible, and never do they say all of this together is incredible or why. Okay, next slide, please. So if you think they're wrong legally, like they're asking for documentation of an immaterial eligibility requirement, one question is it legally required, or are they arguing this is discretion? And those of you who've been around a while know this is the big problem with the U waiver review, is that purely regulatory prohibition on review of discretion in U-waiver denials, as opposed to whether they're identifying the right grounds of an admissibility. It is, and we'll come back to this when they start asking for things that normally would be outside, say, the record of conviction, like police reports, for instance, if they're not attached to a record of conviction. And their argument is they can basically do fishing expeditions for discretion. They wouldn't use that term, but that's what they're doing, is fishing expeditions. They don't seem to think there's any fetters on their discretion. If that's one of the problems, you need to contact us, because this is an ongoing issue. We're trying to figure out ways of arguing, and we have some sample briefs about inadmissibility, especially for U visas, on our website, where people have explored different arguments. Just one practice pointer, if you are doing this in the inadmissibility context, one way we're trying to get you to set this up so there's always a legal issue for review at the AAO is that they aren't applying the D14 standard Congress created. If you look at their denials, they almost always refer to the HRANCA D3 standards and then kind of glom them on to D14. That can't possibly be what Congress intended. So this is actually some good briefing on that we would encourage you to just argue in all of your inadmissibility requests. The other thing that is often comes up, and is important to understand how you argue this, is that they mischaracterize your facts, and then they apply them wrong to the law, or they or they apply the wrong facts to the law. And that's actually a legal argument. So if they're wrong on your facts, you have to show that the way that they're wrong on your facts is affecting their legal analysis. We call it an application of facts to law. That is a legal argument, not a purely factual argument. And that becomes important because that will determine what kind of motion, for instance, you may do down the line, reopen versus reconsider. Always, as Laura said, you got to respond timely, which again is please contact us as early as possible. For one thing, these arguments do keep evolving, and we may work with you on developing a new argument. We will still have you ask for supervisory review through the email hotline, and we'll ask you to CC us, one of us, whoever's helping you, so that A, they know that we're watching, and B, we can see what happens in their response. And then that creates the email trail that we put together with some of the evidence to go to headquarters and to the heads of the unit if we think the adjudicator and the supervisors aren't doing the right thing. So next slide, please. So if it's purely factual, if they mischaracterize the evidence you supplied, then I think this goes back to that they're applying the facts inaccurately to the law, but you still need to come back and say, no, this is not what we said. Please read the highlighted versions. And again, we can help you figure out how to do that and raise that, because to me, that's an adequately trained adjudicator if they can't understand your facts. Like, I think we're seeing a lot of adjudicators who don't understand domestic violence, and so they're not understanding how the facts you're supplying are showing extreme cruelty. Or if they're just wrong about what you supplied. Again, that's an easy reply, I think, and we can help you with that. And I already discussed how if we're going to want to take this higher as opposed to just fix it, then we make the argument that they're applying the facts to the law inaccurately, and that's a legal thing that can be reviewed. Next slide, please. Okay, here, so I want to do an RFE, especially on marriage fraud. We're seeing that in the U visa context. I think that's been fixed for now, but it's marriage fraud or bona fide marriage is still the big reason that they're denying VAWAs. So typically, they may come back and tell you they have information that marriage fraud occurred, but they won't tell you anything more about it. One thing to first aggressively question is, where did you get this information? Was it a violation of 8 U.S.C. 1367? That's a very important statute if you're not familiar with it to download and look at. It's not only that you can't share information part, which people discuss as confidentiality. There's also a presumption in there against evidence from certain parties, especially abusers and perpetrators and anyone associated with them. It's essentially an acknowledgement that those people lie all the time to try to harm their victims. So even though it's a presumption, they can get around it, but we need to be pushing very hard that it's a violation of the law to be violating this presumption, and moreover, there's a possible $5,000 sanction. And hopefully, and again, come to us about that, because this kind of thing I want to take to headquarters, because I think we really need to push them if they're having conversations with local offices who are talking to abusers, or ICE, which is I think where a lot of this is happening. And we may need to want to start briefing this and going into federal court to challenge it. The other piece that they often don't do is follow their own rules on when they're denying for derogatory information that you don't have. It's a fundamental due process principle, right? That you should have notice of the problem and an opportunity to respond. Otherwise, it's just a black hole, and it's basically, what do you call it? Decisions that are not based on law or facts. They're just, because you can't tell. It's just them saying no, and we're not telling you why we're saying no. The only exceptions are classified information, and I have never seen that come up in these cases. I have seen them when I was doing work in the 90s on secret evidence. But if you're seeing this, and I do think this happens a lot, contact us right away, because I want to take these to headquarters. I don't think they're adequately trained on this, and I think there's maybe things going on at the agency that we need to FOIA and challenge. Next slide, please. The other ones that we're seeing a lot of they're alleging gang affiliation. It may be because some of your kids are showing up on some local database or something. What can you find out about that yourself? So doing FOIAs to them, doing FOIAs or whatever the state version of that is for the police databases where this is coming, running those criminal background checks. And then I think in terms of the problem with gang-based allegations, I think, is that they're not based on facts for the most part, except for the fact that you're in some database. But you're not in a database because of any other fact than you have tattoos, or you wear baggy clothes, or you were standing on the wrong street corner in the wrong neighborhood, or you have a Latino name or something like that. So it's hard to do because the government in general, it's very hard, I think, at every level to get them to look behind this gang-based allegations. But I think we need to be challenging it both on the facts that you know, and I also think it's a serious constitutional problem that they're making these decisions about you based purely on what I would say is protected First Amendment activity, if there even was any protected First Amendment activity. It's not based on acts, it's basically based on status, I think. So, bigger picture, I have heard of people occasionally winning these cases, but it's hard. So again, if there's any way you can flag this stuff ahead of time and head it off at the pass, I think that's going to be a lot more helpful. Like say, yes, we know that you're going to find that he's in a gang database, but here are all the facts to show that that's just factually inaccurate and was based on whatever you think it's actually based on. Next slide, please. I think, are you taking over here? Yes. Laura, and I'll go back to the questions if you'd like.
General response, hang on.
You want me to do this one? I am happy to keep going.
Sorry, I was on the wrong slide. Yeah, if you want to just, oh no, I got it.
Okay.
Oh yeah, I had you on it, sorry.
Okay, all right. Well, again, many of you have heard me on this, which is, I actually did some deep thinking about this about a decade ago when people were arguing. I think people thought for a while that any credible evidence meant you just supply credible evidence and that's fine. That's really not how it works. I think you need to go kind of deconstruct what credible means. Yes, it's a very flexible evidentiary standard, but to show it's credible, you have to show it's either the best evidence you could get or why you couldn't get better evidence. Well, yeah, why you couldn't get better evidence, why this is the best evidence you can get, and then why it is credible given that. So often the whole point of the anti-credible evidence standard, right, is that abusers and perpetrators control systems and control documents. So you're often not going to be able to get primary evidence, which is what they would normally think is the best evidence. So you just quickly describe that. Why didn't she tell the people at the hospital what was happening? Why didn't she report it to the police? Why, when he did report it to the police, did he not say blah, blah, blah? Heading it off at the pass, I still think is a really important approach. I'm not changing that paradigm yet. And then, how did you try to get that? So you can show you can't get it. Like there's often long time problem of getting LA police reports for good moral character for VAWAs. You can usually get a standard letter saying we don't supply these. The other typical one is, records of delinquency because of confidentiality and privilege issues for children. And then what is it that you're submitting that serves the same purpose as that kind of shorthand primary evidence? So again, I think this is making them understand why they have these shorthands, like why they want primary evidence is because they think that is a reliable source of information and that what they're saying is probably true. You can't get that, so what is another reliable source of information what they're saying is probably true? And we'll come back later to how you can set up your corroborating declarations from counselors and others to supply that if you don't have anything else, basically. Next slide, please. So just to review, there's a difference between the burden of proof and the standard of proof. The burden is the total amount of evidence that you have to show to win. So the one that you hear about all the time if you watch television is beyond a reasonable doubt, right? Because that's the burden for criminal cases. And you may know if you do other kinds of immigration cases that there may be heightened burdens in certain kinds of immigration cases, which I can't remember what it is, but it's not preponderance. Clear and convincing. There are some cases, like if you marry in proceedings, I think that the burden for showing good faith marriage is clear and convincing. But for VAWAs and U visas, which is a fairly standard burden in immigration, is preponderance of the evidence. And technically, that means the adjudicators, it's 50% or more likely that the evidence you've supplied has shown eligibility, which is a pretty low standard. I don't think that's what they're actually doing. I do think it's worth reminding them there's a difference between any credible evidence, which is the kind of documents you can supply, and whether that adds up to, in a totality, to meeting the preponderance burden. And that again brings in that totality thing, is that to meet a burden, it can't be each piece of evidence needs to meet a burden. It's how all the evidence together meets your burden. Next slide. Oh yeah, it was on here. Okay. Okay. Primary, secondary, other credible evidence. I wouldn't worry too much about secondary. I think often the any credible evidence you supply is actually kinds of secondary evidence, but we're not limited to that either. Anything that you can find, or the domestic and sexual assault counselors you work with can find that's credible, and you can, show kind of foundation, as us lawyers like to say, for its credibility. Use that, because that's the beauty of this, is you can use anything that's credible as long as you show it's the best evidence you can get, and that if you add it all up, it meets your burden of preponderance of the evidence. Next slide. So I'm hoping the audio is okay. I'm seeing Jennifer said she lost audio.
And I followed up with Maria and Alam, so hopefully they're taking care of that.
Okay, good. I also know I'm talking fast, but that's because we have a lot to get through. And you will have the recording later if you need to listen to it again. Okay, so again, this is just another version of what I was saying, that the special kind of evidence, the evidentiary standard is any credible evidence, still needs to add up to the burden. Next slide, please. And there's actually a great memo, which I don't think is framed as a credible evidence memo. I think it was a memo that Paul Virtue sent out in 1998 when he was at, I think it was INS at the time, and that was when VAWAs still had to show extreme hardship. So there's a long discussion about how VAWAs can show extreme hardship, and then it goes into what's credibility, because people have been asking for it, and there's some excellent language there that we routinely cut and paste and put in our amicus briefs, and I suggest you do now, especially if we're dealing with adjudicators who I don't think have been adequately trained. And you can get that memo from our website if it's not in the Dropbox. But so basically, it's kind of standard credibility. The part about it I like is that it really acknowledges this power and control dynamic, and that's probably why Congress created this special standard. It does say it'll do case by case, which makes sense. It's all idiosyncratic, the experience that survivors have, whether it's a U crime or T crime or VAWA. You don't want to sound like you've read a website, right? Because they're going to think fraud. So practice point we're going to come back to again later is nitty-gritty, crazy detail is actually really helpful, because they know that it's very idiosyncratic. Then again, that internal credibility, which is what we already talked about a lot, which is check, all these kind of, whether it's material or not, all the things within an application and with prior applications that they're going to be looking at, if you have them, to see where there are inconsistencies. Okay, next slide. I think.
Okay, back to me. Yeah. Okay, I'm really at this time. General RFE response tips. So we're starting with kind of going back to the basics. Always review the front and back of the RFE and every single page of the RFE. Sometimes we're going through it and it looks, the form itself may look very boilerplate, and you're thinking that they're just reviewing, the standard. They're not really getting to the nitty gritty of what they want from you on your specific case. Review it all. Sometimes it's thrown in there halfway through with one paragraph about, and this is what we want from you. So front, back, all pages. Always respond on time. So I know we keep saying this, but I know there are going to be many times where you're going to want to get in touch with us right away, because it seems so obvious that this is a USCIS error. Yes, do get in touch with us, because we need to be able to advocate, but unfortunately, advocacy is not going to get that case approved, and missing a deadline will result in a denial. So respond on time. Also there, if you know that there's something you don't have. So what if you can't fully respond on time? So one thing you might want to do, okay, obviously, give as much information of what you do have and why it's answering the RFE substantively and completely, if that's the case. But if you don't have fully what they have, why don't you have it? Is there some reason that you think this document exists, but your specific client can't have access to it? The most common example that I think we see is, the victim can't get the abuser's proof of USC status, right? So what did you do to try and show that? Well, she has a copy of his driver's license, and we know that in the state where they live, the laws require that the person have either citizenship or lawful status, or even in some states, actually, they have particular codes that they put, which is terrible, but they have particular driver's license numbers that are specifically for US citizens and driver's license numbers that are for LPRs, which is terrible, but that may be a way that you differentiate, hey, this is what I do have. And, obviously why you can't get it, well, she doesn't have access to it. Part of the abuse, if she's still living with him, obviously part of the abuse, if she's not living with him, don't have physical access to it. Why what you did supply is credible and sufficient. So going back to the assessment that Gail made earlier on evidence. Okay, next slide. Be civil. I know, especially when these RFEs seem so, sometimes they just come across like they are either stalling, they just need more time. They want to just throw out a bunch of boilerplate RFEs in a bunch of cases to kind of catch up. And so it's very frustrating. But the bottom line is that it is going to be a lot better if you say something like, we know your adjudicators are dedicated to helping survivors, but we respectfully suggest that this RFE illustrates an incomplete understanding of the context of domestic violence in the following ways. And then you say exactly why they got it wrong. It's going to be a whole lot better than saying this adjudicator clearly knows nothing about domestic violence and isn't even trying. Okay. Not that you would say that, but you'd be surprised what we have seen. So be civil.
I can relate. I am a ranter, and I'll tell you that before I communicate with the government, I have to rewrite my emails like 4 times. So if you have a rant you'd like us to help you make diplomatic, let us know.
Yeah. In general, just focus on why they are wrong factually, rather than attributing attitudes or adjectives that may describe officers. Okay. Always put your RFE on the original RFE on top of your response package. Never respond to the RFE via email. It's never going to work. Even if you're going to notify Vermont Service Center hotline because it seems to be a training issue or a clear error, that's just not going to be enough for responding to an RFE, even if you later send it to bring it to their attention. Always get a tracking number and delivery confirmation. And this is especially true now. I'm sure many of you who are on VAWA Experts listserv have seen a lot of members talking about how FedEx isn't delivering when they thought they were going to deliver, or FedEx did deliver on time, but USCIS is saying that they didn't get it. So those confirmation and tracking delivery will be important, either to say, look, I asked for expedited overnight. I paid for expedited overnight. FedEx promised expedited overnight, and this is FedEx error, and this is why, unforeseen problem with FedEx, not you. And if you can get something from FedEx saying that, then that's even better.
And we have historically done a lot of interventions where you can show they got it on Friday and they say they didn't get it till Monday, and I'm not going to get into why they do it, but you don't need to spend a lot of time arguing with them. We'll help you, because I can just go straight to the top and say, you remember this conversation?
Right. And quite frankly, USCIS, whether or not USCIS picks up their mail on a particular date doesn't mean their mail didn't get there on a particular date. So don't waste your time. Okay. Next slide, please. Okay, so now we're getting into how do you prevent RFEs to begin with. Next slide. along. Next slide. Oh, there we go. Okay, so avoid problems up front. Make your best evidence arguments right from the get-go. Why is primary and secondary evidence unavailable? Don't wait for them to come back with an RFE asking you to spell out why you didn't get XYZ. Just spell it out yourself. We know that this document may exist, or we know that, birth certificate is best evidence for proof of where the person was born, but this is why we can't get it. This is what we did get. We got a baptismal certificate from the same town a week after the birth or whatever, or the baptismal certificate actually includes the date of birth if that's what you're trying to prove. So go ahead and present that up front rather than waiting for an RFE. Find your holes in your case, basically, and fill those holes with as much as you have. So your client's efforts or your efforts, why the best evidence doesn't exist if it doesn't exist, or why you believe it doesn't exist, how your evidence is credible, and again, totality of the evidence, preponderance of the burden. So it may be that you don't have your primary evidence, but you've got 10 documents of secondary evidence. You may be able to meet your burden that way in looking at the totality of the evidence. Okay, next slide. For fact-based issues, get into nitty-gritty detail. The more detail you can provide, and I think if you've sat in on a bunch of several of our webinars in different contexts, we always talk about detail equals credibility, right? So this is a great example. So he always watched me, even when I was home, as opposed to he moved the sofa in the living room. He said so that he could sit there and have a direct line of sight to the kitchen while I was cooking. Well, that's super descriptive. That is less likely to be something that someone quote unquote makes up, right? It just gives a little bit more detail to paint the picture and just gives that credibility to the victim. Next slide. Criminal history. So obviously we want to connect criminal history to victimization, and we give the example here, substance abuse as coping mechanism, which is very, very common unfortunately for a lot of our victims, right? So what if that is the issue that you're dealing with? Let's say you have a DUI, then how are you going to convince USCIS that despite that, it's connected to the victimization? And what steps has your client taken to make sure that they're not a risk to the community, that it's not a safety issue, right? So detailed declaration, recognizing that the person, that your client, the survivor, has a problem, and articulating specific steps that the client's taken. So be specific. If you're saying that your survivor or your client attended a rehab program, what was that rehab program? Was it court issued, or did they go on their own? I think that's important, particularly if they did go on their own. That's super helpful. Maybe their counselor put them in touch with the right people and got them into those programs. Well, that's great. So get the counselor's letter saying, yes, I referred her and she went. And this is why that's such a big deal. Only 30% of people who I refer actually go, or only 30% of people who go actually complete it. And not only did she go, she completed it. It's a big deal. So if you can have her say it, but then the counselor back it up, it will be, it'll go that much further on the criminal issue to favorable discretion on it. Let's see, next slide.
Wait, before you move on, just a couple points on that. I think this is even true when it's connected to victimization. I think it's a mistake to provide excuses only without,
sure.
right? Right. And
Right.
this is why I have this convince a neighbor. I usually say it's the barbecue analogy, you know.
Right.
Try to convince a normal person that you'd want this person living in your neighborhood because, um, you know, the fact that it's connected to being a victim, if you're going to be the driver for a drug dealer again, that's not going to be, I don't want you living next to me. If you're not actually trying to stop drinking and you're an alcoholic, I don't want you living next to me because you're going to kill my kid when you're driving drunk. So, you know, you got to step back and think about it. It's a normal person. What would you want to see? And that's why I think a lot of the times lawyers tend to really focus on like what the case law says. The difference here is you're trying to convince these people where we really have no way to challenge them except through their own system. And even if we go to federal court, they're not going to get in the weeds as much on this kind of thing. So you got to, it's in their own words, convince them that they have seen the light. And it's really hard if they're in detention. And so we often brainstorm with you is like, is there a way they can follow the AA programs and take notes on what step they're on and, you know, and what have they been reading? Have they found religion? You know, because it's very hard to do the kind of documentation that people outside detention can pursue, basically.
Yeah, and actually a couple of other points actually, since we're just talking about criminal history generally and avoiding RFEs, run fingerprint criminal background checks before you submit. If your client has already told you, you know, that they did have issue with alcohol, but they don't say that they had a DUI, run the background check anyway. Maybe there is a DUI. Maybe they didn't see it as a big deal because they were told it's just your first misdemeanor and it's not going to go on your record or whatever, you know, they were told at the state criminal level. And so they don't feel like they have to disclose it. Run your fingerprint checks, not just a name check. Fingerprint check is just going to be better if you know that your client does have a criminal issue, but the client isn't sure exactly what happened in court. Rather than just submitting your FBI fingerprint background check, do your local and state. Maybe your state has a state Bureau of Investigations that runs its own checks, and that sometimes is more accurate than FBI, which doesn't always get reporting from the state and local jurisdictions. So always run it before you even file the case, which again goes back to knowing your deadlines up front. When you're running, sorry, go ahead.
Oh, no, you go and just tell me before you're moving on, because there's a couple of questions here I want to address.
Oh, sure. And then the other thing I was going to say in terms of just kind of your, in looking at a practice pointer for your representation, does your client contract include some kind of standard language that says client's responsibility, you know, in the section where it says client's rights and responsibilities, your client is responsible for providing honest information to you. If you ask specific question, have you had contact with police, and your client says no, and later you found out that she did, and the case is at that point at a difficult posture, you know, unfortunately we are in a situation where we do have to protect our interests as well as attorneys. So look at your client contracts and see whether you need to do anything to kind of beef those up and make sure that your client knows what their responsibilities are in providing truthful, updated, honest information. Okay, sorry, Gail, go ahead.
No, that's fine. So a question from Diana on your fingerprint. What if your client's too afraid to go to, you know, the police for fingerprints? Can you get your own equipment? Are there other places they can do it that would suffice?
Yeah, so that's a great question. And so there are some, not, I mean, and a totally valid point of being scared to go into getting fingerprints at a law enforcement agency. So first off, is there a nonprofit organization in your area that has fingerprinting potential? Because a lot of nonprofits do get trained on doing the fingerprint cards with ink. There are some that have electronic, although that's getting trickier because I think you have to actually log into a federal database. I don't know all the ins and outs of it, but I remember researching it. So I know that there are definitely nonprofits that may do at least inked fingerprint, do the cards, and then in some instances, they'll submit them, or if you want to submit them, then just have them go to the nonprofit, get the card done, come back to you, and then you can send it off yourself to FBI. So there's no requirement that they have to have the fingerprint done, the fingerprint form filled out by an LEA. So yeah, look for that as an option. The second thing I would say is, this is another reason why developing relationships with law enforcement agencies. So when we're developing those relationships on certifications and on protecting survivors, also develop those relationships to say, and on a more practical level, we'd like to be able to get fingerprint checks done for our clients as part of this process and getting their situation stable. And could your law enforcement agency agree to help us without, without locking them up?
You never know. One thing I've learned from training law enforcement for a while is that your stereotypes often don't apply when you're talking about individuals. So.
I will tell you that's absolutely true. I used to practice in Tulsa, Oklahoma, which is as red can be. And our Tulsa Police Department had a wonderful community, Hispanic community outreach. Well, I was going to say division, but really it was one officer who was really, really great. Division. And once we developed the relationship with them, and then we got in there to be able to train at their CLEAT, CLEs or whatever they're called for them. Then the officers get to know you, they get to trust you, and then at that point you can make your asks, and they're like, oh yeah, that totally makes sense. No, they shouldn't be scared to come in.
Yeah, and I wrote an article years back for LexisNexis on kind of social psychology of working with law enforcement, which is a whole bunch of practice pointers. So that's on our website somewhere. So the question that came up, so I don't forget, is how do you make these arguments about criminal history for derivatives? And so a couple points is, I think that the best way to deal with derivatives, especially the ones who refuse to change their behavior, which unfortunately seems to be true with a lot of teenagers, is focus on the harm to the principal of the child being deported or denied status. Why, as a survivor of crime, becoming a thriver, do they need to have their kids, even if the kid's a problem? And the reason the kid's a problem is because they lived in a violent home. I'm seeing a huge number of denials based on juvenile arrests. The second issue is, what do you do about the fact that these are often not actually convictions? And we're not going to get into a lot of this today, but that's the problem, is they're going to want to know the facts, right? So just saying it's a juvenile offense and therefore it's not a conviction isn't going to answer it. If you have a system that refuses to share the information, that may help, but they're still going to want to delve back. And I actually recently did a training for judges, which had a bunch of juvenile court judges, and they're now going to amend their notice of consequences to include consequences for juveniles, because they were so taken aback by what happens, how what they do is used against juveniles in the immigration system. So, not a helpful answer, but again, we're here to help you figure out what to do if you've got those problems. It's going to be very fact specific often, both with what the offense is, what the juvenile's attitude is, and how strong the principal's case is in other ways.
Right. And then also, what are you at the point where you need a waiver, or is it for discretion purposes? Right. I think that makes a difference too.
Right. Well, because how can you waive a juvenile offense? Because it doesn't trigger.
Right. It doesn't need to be waived. Right. So then you're talking about, your public policy or your discretion. Yeah, exactly.
So Douglas has a question that kind of harks back, is how do you supplement a U visa if it's in, I assume you think it's in danger of being denied because it wasn't complete at time of submission? I think this goes back to, the kind of practical, how do you supplement a file so that it doesn't go off into a black hole? And I think you kind of addressed that already. If you want to.
And I'll just repeat it real quick in case you didn't see the response. So generally, if you know right away that you didn't submit something you should have, or the information just came in, you just got your FOIA and you see that maybe you need to do a waiver for a different immigration offense that you didn't include, submit it right away. And so what I mean by submitting is actually mailing a written supplement that, so you'll do a cover letter just as you would for any submission, but at the top of it, I tend to go overboard and I will put like in huge, bold font and sometimes in color font. If you don't have a color printer, don't worry about it. Use a color marker. Honestly, it works. And just put supplement to application or supplement to petition, right? And then in the reference line, put your EAC or NSC, whatever your receipt number is, and then spell out what you're supplementing. Well, I'm supplementing the I-192, and here's why. Just got this information. This is what it's going to show. I'm amending the waiver question, and I get specific. So if you have to supplement the actual form, don't submit a whole new form. And I just say that because it ends up causing a nightmare in the mailroom. They see a new form, they want to see a fee, right? So to avoid that, I created a separate document that just is supplement to I-192, and I will put question number, like let's say it's part 2, question 7. I repeat the question as written on the form, and then what your new answer is, right? And then, you're going to have your client sign the supplement because you want it to be included as part of the original form, and then include any evidence with it. Now, does it always make it to the file? No. But what have you done? You've created a paper trail. You've created a paper trail that you submitted that information, that evidence, if they consider it initial evidence, that you've already submitted it and did it as soon as possible in order to avoid an RFE, a NOID, or a denial. So after you do that and submit it by mail and you have your delivery confirmation, contact the hotline and and just flag it for them. And if possible, put supervisory review on your email and just say, I've submitted this. This is why I submitted it late. It's a supplement. I just want to make sure it matches up. They may not respond, but again, you've got a great paper trail.
And Magnolia wants to know whether you want to do a new I-192 or just say you're basically amending the old one or supplementing. I think you can do it both ways, but you may want to contact us. Again, I'm going to keep saying this. It tends to be kind of fact specific which way you're
going. Let's say case by case, because what if you're amending every single question, or you've never submitted one, or whatever? Yeah, contact us.
And it kind of depends. Yeah, I mean, I don't think there is one way to do that right, to be honest. I think there are ways to do it wrong, but and then there are a couple questions about the emerging issues, the fee waiver issue. I just want to let you know that a couple things. We're not going to get into the details here because we recently did a webinar on this, and we're actually, I hope you all got the template fee waiver comments, because comments on this are due on Tuesday, and we created a template where we want you to put in facts of your cases that illustrate the larger points. And we're still working on a kind of voluminous comment that we're going to try to get actually some litigator groups and some DV groups to sign on to, because the other thing we're doing is trying to organize and coordinate both litigation and FOIA on this, because obviously the direct advocacy that's worked in the past 20 years for us is not working now. So we're exploring all these other change approaches. And the arguments that you're going to make are still evolving also, but they're also different pots. There's the, they suddenly changed their standard after I'd filed this. There's the without notice. There's the they're not even applying their own standard correctly cases. And then the worst cases in some ways are they're denying the fee waiver at the very end of an appeal period, which is essentially the same as denying your case because the time has lapsed, or the motion to reopen time has lapsed. And those, I think, are the ones that we need to immediately litigate. So if you didn't get the fee waiver template on VAWA updates, let us know. You should all be on VAWA updates. It's only one way, so you're not going to have a lot of traffic, but there's so much happening and so much changing right now. The only way you're going to be up to date is if you're on that list there, frankly.
And the final point I'll make on fee waivers is, in addition to all of that work, we're also in the process of updating our practice advisory, which I know Cecilia had put out an extensive practice advisory earlier this fall. I actually don't remember if it was August or September, but in any event, based on the changes to the fee waiver policy that are now coming out, we're in the process of doing an extensive overhaul and of that practice advisory, so be looking out for that.
And similarly on the NTAs, we're going to cover it briefly at the end if we have time, which also reminds me we need to move through this
Yeah,
a little
we're at
faster.
50 minutes,
Yes,
Gail.
we're also working on that, and we'll come back to that at the end. Okay, let's move on.
Okay, so this is you, Gail.
Yeah, Ingrid, what I'm saying is you can either supplement or you can do a new one. It's going to depend on your case. So she was saying I was contradicting Laura. Probably I was. Okay, so this is me. I think we've covered a couple of this. Next slide. As I think I already covered the good faith marriage issue. If you're seeing that, some how to avoid it strategies. We got this directly from Vermont Service Center folks when we were actually able to do trainings with them. So it's a little old, but I still think it's actually good advice, which is what they're really looking for here is nitty-gritty detail about the courtship, how they decided to marry, and then what their life was like after they're married. So, and this isn't like, I think you have a good slide later that illustrates this, but it's what my way of addressing this with you is go through any declarations you have, whether it's your clients or people doing corroboration, highlight any adjectives, adverbs, or opinions, and make them turn all those into actual facts. So, because they want to hear your client's voice and they want to hear the real story. And again, the more idiosyncratic detail, the better. So we would shop every Friday and he was in charge of the meat department and I was in charge of the vegetables and he always bought this meat. That kind of thing is what makes it real to them, not I loved him, or corroborating declarations that say I saw them and I know they loved each other. No, I know they loved each other because what are the facts that showed that? So that's one way to set it up, and that also then gives us the teeth to help you appeal it if you get a denial. And we've supplied in your materials 2 amicus briefs we've sent to the AAO in Word format with a bunch of legal arguments and how they're applying facts wrong to the legal arguments. Literally take, cut and paste those arguments and apply your facts to them. We need to keep pounding and pounding at the AAO, and I think we're going to have to take this to the federal courts if the AAO keeps just rubber stamping Vermont on this, because I think they're applying a higher good faith marriage standard to self petitions in many cases than they do in regular family-based cases, which is like the opposite of what they should be doing. Anyway, this is an example of me ranting. Okay, let's move on to the next slide. Abuse. Now, this started happening when they moved all these new adjudicators in, which on the one hand was good because things were going a little faster. On the other hand, is they just don't understand domestic violence. So if any of you are still seeing this, the one basic evidentiary problem we were seeing that we've again hashed out with them over the years that you shouldn't spend any time on is any dismissal of corroborating declarations because they're from people who didn't witness the abuse firsthand. I mean, DV 101. Abusers do not abuse people in front of other people. They're smarter than that. So they agreed that hearsay was fine. And again, this goes to the credibility of the people providing corroboration. And there's some guidelines for counselors, others that you seek to do corroborating declarations that we've given to you. They're not templates because we don't want them to look like, templates. We want them to look like their own story, but it tells them what to do in each paragraph in case it's kind of a psychological barrier for them doing it. As it says, same thing I've already covered. Facts, not opinions. Going to counseling session proves nothing to them except that they went to counseling sessions. They need to talk about why what they heard they believe was true, why it was a form of domestic violence, and they may need to explain to the adjudicator why it is a form of domestic violence if it's not battery, right? Because they may not understand economic control and degradation and humiliation and all those other things that we are so familiar with. Okay, next slide. And I think I just covered this. Again, if you want to use these, you could literally take those guidelines, you can beef them up. We wrote them years ago, and give them to the counselors you're working with and other service providers, social workers or hospital workers or whoever, teachers, whoever is working with you that can provide corroboration. Yep. Okay. I think this is back to you, Laura. Bad audio. Sonia. Hey, Sonia.
Sorry, I think I'm back. Am I back?
Yes, now you're back. I think, Sonia. Let us know if you can hear Laura.
Okay, so U and T visa related RFEs. We just talked about VAWAs, so let's talk about U and Ts. These are just common ones, not necessarily all of them. Okay, so criminal case after filing, we kind of talked a little bit about getting documents, but client is a teenage child of a principal mother, mom, a victim of domestic violence. After filing, client is charged with misdemeanor assault and gang violence and gang related violence. Involvement. Good God. Okay. So the documentation that is being requested in the RFE is, of course, police report, because they want to see that, right? So let's take a quick poll. Next slide, alum. Okay, so again, if you could just put in the question section where you guys have been asking questions, do you notify USCIS? Let USCIS know right away that there's a pending criminal case. That's option A. Option B, wait for an RFE. Option C, update the application later to include evidence and additional equities. Option D, update the application once the criminal case has been completed. I'll give you some time. Again, teenager, mom is the principal, victim of domestic violence. Client's charged with misdemeanor assault and gang involvement, and the RFE is asking for the police report. What are we seeing, Gail? A, B, C, or
D? Well, basically not A. We're seeing D's and C's and a B, but no A's, and a couple combinations.
D's and C's.
We have one A. Okay. Yeah. All right. So basically, they're all over the place.
All over the place. Okay. And well, so generally, it's all over the place probably because it's going to depend on a case-by-case basis, right? What does the police report say, right? We want to know what's in there. And if it's going to damn your client, then you want to get all those additional equities. So I can see why you would say, hey, let's not submit it right away. Let's get those additional equities together and then submit it. And I think B and C is probably a combination, right? Wait for the RFE and then do C. And then D, once the criminal case has been completed, then submit it. Obviously, you want to argue that, yeah, this is just a charge. Nothing's been verified. Nothing's been proven. And so USCIS should not take that against your client. Unfortunately, the RFE may come and the deadline for responding may be before the criminal case has actually been completed. So you'll have to take a look at what is the most information or evidence that you can get regarding the criminal case. What are the equities that you already have in place? And can you argue that the police report, that is flawed in some way, right? Legally, factually, or does it even apply to your client, right? So I think in general, I do think C combination with B arguing for D. Yeah. So case by case, right? And if you need to walk through that and talk about your specific case and which is the best approach, come up with that approach and then talk to us if you want us to take a second look. Okay, so next slide.
Wait, before we move on, just a couple comments.
It's still going to be on police reports. That's why I was going to move on, but go ahead.
Oh, okay. But so, I think A might have been what I would have suggested 10 years ago. But this is the paradigm shift. They don't understand crimes, and you don't want to be putting it on their plate unless you have your arguments all ready, which is why D is great. But you also don't want to have the criminal case over and then wait for the RFE, because you always have the issue of credibility, right? If there is something material that you haven't shared, your credibility is very difficult. Your problems are difficult to overcome. So again, this goes back to what you're saying. It's case by case, but these are some of the considerations involved.
Yeah, and actually that's a great point, Gail. Is it material, right? Is it material to whatever derivative petition they're filing at that time? And if it's not even, like, let's just assume worst case scenario, there is well, okay, misdemeanor assault and gang involvement. Okay, I see our facts. Yeah, it probably will be relevant somewhere. So yeah, but if there's an argument to be made that it's not material, you'll want to argue that. Okay, next slide. Okay, if you get an RFE asking for the police report, what do you guys do? This is another poll. Do you submit it, explain why it's not legally or factually relevant? Do you not submit it and explain why it's not legally or factually relevant? Or what else do you do? What do you do in your practice when you get an RFE for a police report?
So Laura, I think we're just going to have to discuss this and move on because we got to catch up a little bit, I think.
Okay.
So this, as you said, this is very similar to the other one. I think what we're asking you to do, if you've been to any of our trainings, is to make the arguments about why this, for the same reasons they're not allowed to do it for convictions, that they shouldn't be allowed to do it here. But then it's up to you whether you want
Right.
to do it.
And if you need materials on that, there are great materials at our clearinghouse. So take a look at the website.
Yeah. So I think we need to book it a little bit, make sure we don't.
Okay, so next slide's yours. Let's go into categories.
All right, so I'll do this very quickly. If you haven't seen it, the AO in an unpublished decision seems to agree with us that robbery may fall in the category of felonious assault. And so the framework is that, and please don't argue similar crimes. I just think that's a losing argument. And they agree that these are categories of crimes. And if you look to the domestic violence category, that creates the framework that should apply to all the other qualifying categories. So that's what I'm going to say. The other thing I would suggest to you, because I do a lot of TA on this, is don't just make your legal arguments, which I do think you need to do. You also need to make this accessible to people who aren't attorneys. So I like the chart idea, which is what I learned from Sonia, where like on one side you'll have the elements of your, say, I think I just did a misdemeanor DUI. Could that also be, no, felonious DUI? Could that also be felonious assault? The question, to me, the answer is, what are the elements of the felonious DUI and what are the elements of felonious assault? Compare where they're the same. And then when you're missing elements for felonious DUI, what are the facts that meet the elements of felonious assault? So you could, our argument is that with a combination of elements and facts, you should be able to show something fits in a category. And so one of the issues that is the problem is that the other box is now gone from the law enforcement certification, right? So I think it's a question, I think we need to do more educating with law enforcement and working with them in these kinds of cases where it isn't obvious which box to check. And we're not going to get into that now because we don't have time, but we'll love to do that with you, an individual TA. Next slide. Hey, Joy. So Joy mentions back to the police reports that I guess your experience is they're denying them if you don't submit it. We've actually seen people make the legal arguments and still win if they don't submit them. So I think it's a bit of a crapshoot, but again, it's going to be case by case depending on what your police reports are like and what your arguments can be about it. Okay, I already said all this. I think one practice pointer here on your SUP fees, I think it's really confusing to them if someone checks more than one box. What I've seen them do is make you prove both crimes, which is ridiculous, but then having to fight with them about it is kind of pointless. So I would suggest you pick one box, and then in the like harm section, you could talk about the other crimes. And I've already talked about the charts. Next slide, please. It's back to you, I think, Laura.
Okay. Okay, so RFEs after the U petition is listed, those are possible. Vermont is saying you can get them as part of just a quality control check, so they're random RFEs. They're random checks of files which result in an RFE when they are reviewing the waitlisted U petitions, or new information that comes to VSC's attention. Now, usually we're seeing waitlisted cases at that point are perhaps coming up on being adjudicated, or having the U petition approved, and that's when new information comes in, usually having to do with the background check, or if another immigration file is at that point matched up with the VSC file and they find other immigration violations that may have not been dealt with. So what happens when you get one of these RFEs? Obviously, you want to answer in the same manner that we've already talked about, but in the meantime, the case is taken off the wait list until the RFE is resolved. So that means issuance of the RFE, responding to the RFE, review of the RFE. It's not until all of that is done that they're put back on the wait list. But in the meantime, their deferred action and their EAD remains valid. Next slide.
I guess, Laura, we're not saying we necessarily think this is right. This is the process, right?
Not necessarily, and especially when they say "quote unquote" quality control. It looks like that they're really just re-adjudicating because maybe it was adjudicated under the old administration, and maybe I'm not saying, but right,
and we'll be coming to some of the similar kinds of problems in other contexts in a minute, where we are starting to develop arguments. So it is worth backtracking to this wait list, then coming back with the same thing and saying you don't qualify problem. One of the issues, just to flag for you, is the wait list is purely regulatory. So that's one reason we're kind of staying away of trying to do litigation on that, although we reference it in litigation. I'll talk about it at the end.
Okay. Another common RFE, continued cooperation with law enforcement. The regs are clear that a new certification is not required, but we are seeing where RFEs actually include that as a response, what you need to submit for responding to the RFE. It's not required. So again, use the best evidence approach, statement from the client, which doesn't have to be very long. It could just say, I'm not submitting a new certification. I did cooperate with the police on this investigation. The investigation resulted in prosecution, didn't result in prosecution, case is now closed, but I was helpful in these ways. That's it. Proof that the case is closed if you have it, because then that ends, the questioning on it. I cooperated and the case was either prosecuted or not, but now it's closed. Push back also, one thing I do want to add here is that where are they getting, this new evidence when we talk, going back to Gail's thought on this, on these RFEs that are just, quality control, where are they getting their new evidence from in order to issue the RFE? Look at whether, depending on what the RFE is asking for, depending on what information they now have, look at whether there's an issue on 1367 confidentiality. Where did they get that information? Okay. Did we take out the I-94?
Oh, it might have come out. Let's keep going though. It might be in there. I'll write it down, so if we don't, we'll come back to it.
So if we don't, we'll come back to it, yeah, because I think that's just been
that was
coming
unintentional, sorry.
Yeah.
Okay, go ahead.
No, that's okay. Okay, so next slide, please. Okay, so revisiting issues at UNT adjustment. Okay, this has also come up. So the client has an approved U or an approved T, 3 years continuous presence in that status. They go ahead and file their adjustment on its face, totally eligible for adjustment of status, and then they get an RFE that followed by a NOID and maybe a denial, just under the adjustment discretion standard, but using one of the grounds in admissibility in 212A. So one example that we're seeing is 212A, 212A2, where there's some criminal issue that would have made them inadmissible. In the U context, an I-192 was submitted and approved. And then now in the AOS context, where it doesn't even apply under 245M, they're saying, well, under our adjustment discretion, we are going to find that we're going to deny the AOS, right? You submit all your arguments. You show them that you've already made these, that you've already shown why it should be approved at the U stage, and they still deny. One thing that I think it's important for the argument that we need to start making here is that the standard, by the time we're getting to the adjustment of status, is different, right, at AOS from the U petition phase, right? So the only discretion at the U petition phase is in the I-192. And what's the standard in the I-192? So
public interest.
That's right. So is it in the public?
Right there.
Is it in the public or national interest? No, for the U waiver, right? Yes. Public or national interest for the I-192. Whereas for the adjustment of status under 245M, it is humanitarian or to ensure family unity or public interest, right? So to me, that says the standard is lower. If you're going to go with just the discretionary standard, the discretionary standard at AOS is actually lower than the discretionary standard at the U waiver stage, because at the U waiver, you already had to show not just family unity or humanitarian or some other ground. You did show public or national interest. You already met that standard. And in this case, you don't even have that high of a standard. You could show humanitarian or family unity and not even have to show public interest. So it's important to make those arguments now. In terms of the T visa adjustment of, sorry,
before you move on to that, one
yeah.
beautiful thing about this is the AO does have jurisdiction over adjustment discretion. I think this is such a beautiful case. It's like, so it was public interest at the waiver, but it's not public interest adjustment. Is there like a different public interest you're thinking about? It's
right.
A beautiful argument. And just that we should let them know, Laura, that the reason we come to these arguments is we were trying to come up with, like, this is like res judicata or collateral estoppel, and we're sure those actually work. And this is something people who don't think that well abstractly can still understand, right?
Right, because the adjudicators are not lawyers. But if you just show them this is your standard and you've applied this standard, it's just maybe easier at this phase to make these arguments and perhaps be successful. And then in terms of comparing the T AOS as opposed to the T non-immigrant visa, the standard is essentially the same. Compelling humanitarian interests under 212D3 waivers, the Haronka standard, right? So compelling humanitarian interests, and for the adjustment of status, it's compelling reasons for favorable discretion. So again, you can show they are at least the same, and probably a little bit stricter when you're talking about the waiver. And in addition, the TAOS standard is actually, if it's been waived already, it's waived for adjustment as well. So if you've already had it waived under this discretionary standard, then how are they now using discretion for the same reason in a negative way? So that's all I'll say about that. But if you have this issue, please let us know, and we would be happy to review it with you and see if it applies in your case, see if we can make these arguments. Next slide. Oh, here it is. Okay, so I know we have to keep moving along, but I do want to just spend just about a minute on this first scenario. We are seeing a lot of RFEs on U's in particular, where the I-94 date is different from the I-797 petition approval date. So expiration dates is what I'm talking about, right? So the U petition gets approved, but let's say either the principal is outside the US as applying for a visa and then coming in, or we're talking about a U derivative, which is the more common example. So let's just stick with the U derivative. So you have a U derivative, U principal has been approved, They get issued 4 years on their I-797. And then derivative has the same I-797 approval, but obviously it doesn't have an I-94 at the bottom because the derivative is outside the US. So the derivative needs to consular process. And so let's assume they get the visa approved, then they just present themselves at the border. CBP at that point has jurisdiction over issuing the I-94, and the regulations, the CBP regulations indicate that an I-94 will be issued for the same amount of time as the I-797 of the principal, right? And so by the time the derivative has gotten the visa stamp and, gotten all their documentation, gotten their visa appointment, gotten their visa stamp in their passport and presented themselves at CBP, it's sometimes months, in some cases, unfortunately, years if they're having a difficult time getting a passport, etc. So they may be entering and their notice has a full 4 years, but their I-94 may be less than that amount of time. Maybe it's 3 years. Because the other factor is, what's the date on the passport? CBP will also look at that, and that's not a regulatory issue. That's actually a statutory issue at 212A7. So basically, the passport has to be valid for 6 months beyond the date of expiration of your I-94. So what if the derivative child just gets a 1-year passport, which we often see sometimes due to cost restrictions or sometimes because their government is not willing to issue them a longer passport, maybe because the parent's not there physically, whatever the reason is. So they may, instead of even getting what the principal's I-797 approval says, they're just getting up to 6 months before their passport expires, which may be less than a year. Okay, so obviously this is a problem. And if you need to look at those I-94 cards immediately, both at the time that your principal is issued the approval, and then again, when the derivative is coming in, look to see whether they're going to have their 3 years to get them to adjustment, or if you have to file an I-539, when you're going to file that. There's a little confusion about that too. We've recently seen some kickbacks on I-539, not all the time. So we've had some cases where practitioners catch this right away, and they already know they're going to need the extension. The form instructions say, file an I-539 for an extension of status as soon as you know you need that extension of status. Unfortunately, the U regs say I'm sorry, not the regulations, I apologize. It's a policy memorandum. It's the only policy memorandum on U's and T's extensions. And they don't really deal exactly with this issue, but the policy says you have to file no earlier, no sooner than 90 days before expiration, and that's causing a mess too. So you already have to extend it, but then you have to wait till 90 days before. Again, not happening all the time. We've seen different application of this policy, but it's out there. So the most important thing is check your I-797 dates, compare it with your I-94. I-94 issued at entry is what is controlling. That determines what your status is in the United States. An approval notice does not determine your status in the United States.
And I personally think this is ridiculous and nuts and want to address it at some point. So do let us know if you're having it. I think we got to really cruise. Can we get through the notice of intent to revoke stuff fast, Laura?
Yeah.
Okay.
Why don't I just, there's automatic revocation standard. And honestly, I'm not going to say anything about it because there's a regulation and it's pretty straightforward. Let's go to the next slide.
If any of you are having these, let us know. We kind of assume this is so new you're not getting NOIRs, but so this is
Right.
background for you.
Right. This is background. Since it just went into effect September 11th, we actually aren't seeing a whole lot. But it's important to know what the regulations say, because notices of intent to deny, in addition to what the new policy says, this is why it's important to go back and look at your regulations, right? Because so for VAWA self-petition, for example, The regulations are the usual revocation and notice standard that applies to other immigrant petitions as well, right? And so here are your standards, right? They can issue a notice at any time, basically for any ground that's not, other than the automatic revocation, right? When there is a necessity for revocation and it comes to the attention of USCIS, they can issue it. But USCIS has to give you time to respond. There is a PM on this. So look at the PM because it gives a little bit leeway in terms of VAWA self-petitioners. Next slide. And actually one important thing though is only BSC has the ability to revoke. So usually for VAWAs, we're seeing that the local office gets the adjustment of status application, and at that point they feel that the I-360 should be revoked. The proper procedure that they should be taken is spelled out in that policy memorandum. Take a look at it because there's lots of memos that have to go into that A file. And if there's an issue there, you want to FOIA that file right away. The local district office has to put a memo in the file exactly spelling out why the visa petition should be reopened and denied. I mean, reopened and revoked. And then VSC, once they get that from the local office, also has to do that, the same thing. In terms of the U visa petition, revocation standard is set out in the U visa regulations. And so that's why it's important, even though there are other revocation standards for non-immigrant visas, take a look at your regs that apply for the visa petition that they are issuing the NOIR on. So these are the reasons, and it has to fall within one of these reasons. One that we've been seeing a lot lately, which is really unfortunate, is derivatives relationship to the principal has terminated. A child gets married. So even though we talked earlier, the age gets frozen, the derivatives age gets frozen at filing, if they get married, that's not protected, unfortunately. That doesn't keep them in the quote unquote child derivative relationship. So that's an issue. And if you have that, just talk to me first before you or talk to any one of us before you make arguments of, well, what if they filed for divorce? There's case law on not doing that unless it's a valid divorce, right? Okay. Next slide, please. Okay, so T visa, same thing. It is specified in 214.11, and it's a little bit more, it's just a slightly different in terms of the standard. So here it specifically spells out that the approval violated the statute of regs or was an error in the preparation, procedure, adjudication. So it could have been your error, it could have been the client's error, it could have been USCIS's error, but the error must affect the outcome. So that's something important to note, that if it does not affect the outcome, spell that out in your response and point back to their own regulations, because unfortunately, what we're seeing in just this is mostly in VAWA, and I think in VAWA because there was a policy memo on it, we have seen notices of intent to revoke in the past prior to this memo issuance. And basically what we saw is it didn't matter if it affected the outcome, it went to credibility. So they were saying, well, we shouldn't have approved it because your client just told us, just answered this question no, and on the petition they answered it yes. Well, if it's not material and it wouldn't have affected the outcome, then it doesn't matter and they shouldn't revoke it. And that's just I just love that it's in the regs and spelled out there. Okay. The rest of them are pretty straightforward as they were in the U's. Okay, next slide. Another reason to look at the regulations is because of the deadline. So within 30 days of the date of notice is very specific in the U regulations, but for the VAWA and the T's, there's no specific regulation on the deadline. And so you have to go to the adjudication field manual, which just says usually 30 days. Essentially, it's supposed to be a reasonable time to respond. What's good about that is If you can argue why more than 30 days is reasonable, then you need to do that. If there's some kind of evidence that you need to respond and it's not immediately available, it's just good to know that that's in the AFM. Always make sure to explain why they're wrong on the law, and if there's supporting evidence to answer it, include it in there. If they missed evidence that you submitted before, put it in there too. Okay, next slide. If the case is denied, you can reopen, reconsider, or file an appeal with the AAO. Look at your deadlines, make sure to meet your deadlines. This is particularly important, again, in terms of fee waiver requests, if you're going to need a fee waiver request. Next slide. Should you file a motion to reopen or reconsider? Motion to reopen is for new facts or new evidence. So something that they didn't take into consideration because it wasn't submitted, but now it's available, so you want them to reopen it. Reconsideration is they misapplied the law or the policy. So no new evidence is being submitted there, right? Or no new facts. If you're going to file a motion to reopen or reconsider, it's the same form, I-290B, which is the same form as the appeal. You file it with Vermont or with Nebraska, depending on who adjudicated the case. Submit a brief with the motion. Take a look at the regulations that I pointed out in the prior slide, because for motions to reopen and reconsider, which is different from the appeal, you have to submit your evidence or a brief with the motion. Okay, next slide.
I think this is me now. So
Yes.
I am going to seize the reins and canter through the rest of this, if that's okay, Laura.
That's perfect. I understand.
Okay.
I'll focus on questions.
So we're doing, and you'll deal with all these questions. Good. So we are actually, the paradigm shift is we used to strongly encourage you to always do motions to reopen or reconsider with Vermont before appealing to the AAO. I think that's pretty much a waste of time these days, from what I can tell. They don't seem willing to even think about whether they did anything wrong at Vermont in terms of decision making. So even though I don't necessarily think the AAO is going to be a panacea for fixing our problems, it is a good kind of testing ground or getting our records in order for going to federal court, which is unfortunately where I think we're going to have to take a lot of this. So just to review, what the AAO will review is, basically the legal inaccuracies, wrong conclusion of law or misapplication of facts to law. That by regulation and in the past, Vermont said they would review even things that were framed as appeals and see if they take them as motions. I don't think you want to delay your cases that long, so I would make it as clear as possible that you want this to go straight to the AAO, and basically Vermont's function is purely, procedural, that they send it along. And do not miss the deadlines with the AAO. The thing that I've learned from now doing a bunch of amicus briefs to them is that, you do the form and you want to the degree possible articulate your arguments on the form, but then you have more time to do the briefing. And besides, if you're going to ask for an amicus brief, they seem very willing to grant extensions of time for amicus brief filing. So if you're ready to go to the AAO on an issue, any of these issues we've been discussing, except the ones we'll have to take to federal court, let me know, because I am really interested in pursuing this. Next slide, please. Right, I already covered most of this. Yes, one of the things that's also great is they do seem to actually exercise de novo review. The big challenge are these last 2 points, which I know some of you have questions on, Vermont doesn't seem to either realize that they have to follow the AAO or they have no system for getting the decisions from the AAO. We've had decisions, I think Jess, who was on this at ICWIC, actually had one of these where they won at the AAO, but we still haven't been able to get Vermont to reopen the freaking case. So this, again, I think is where we're starting to learn. We're going to have to all learn how to go to federal court and do mandamus and all that kind of thing. It's not, and since we can't communicate with them anymore, so we can't figure out with them why this isn't working internally. So be aware of that. And we may want to, if you have a win at the AAO, we may actually want to prepare for going to federal court and doing a mandamus to make Vermont actually reopen the case and deal with it, including all these derivative and ancillary applications.
And so just to confirm, even though they're ignoring them, they should be reopening all the ancillary applications once the appeal is approved, correct?
Right.
Yeah.
I mean, so that's kind of a fundamental point, right? Which is that even though they may be denying, and there may be many pieces to an application, and they may be denying on just one piece, like an I-192, what the AAO is actually considering is a denial of the full application and everything contained in it. So once they send it back, unless they're specific about something they want Vermont to address, it's like the board and judges, right? It's like that the case is now open again. And to the degree the AO has told them what to do with a specific part of it, Vermont should follow it, but the rest of it may still be open to them trying to find another way to deny, which is unfortunately, I think, what we've seen. Okay, next slide, please. Yeah, this is the question. I think there have been some questions about whether you can just appeal the 192. I mean, no is the answer. That's like saying I'm just going to appeal substantial harm. So in you're really appealing is the denial of the case based on the denial of that piece of evidence. And so that means you really only need one 290B and fee or fee waiver. You shouldn't have to be filing separate 290s for the different pieces of an application that they denied, because ultimately what they denied was the application in which all those pieces were contained. Next slide. So I'm just going to do this, and if you have any thoughts on it, Laura, let me know. I think that as Laura set up here, I think the big question is there something that's worth it? Can you refile is one question, right? And then also practically, do you have what you need to refile? And I think one question we have when we're working with some of you on these cases is how confusing it is to the system if you have an appeal and you're also refiling, like I'm doing it one right now, on whether you file 485 again and appeal the denial of something else. And again, some of the questions are going to be, I mean, some of the obvious reasons you want to do this is to get work authorization, right? Again, this may go back to some of these issues that we think are wrong, where they're saying they're basically cutting off your status until they revisit your responses. If there's a way around that and your client really needs to work, there's a lot of wiggle room right now and procedurally for sure. And talk to us if you have thoughts on how you want to do this. And maybe we can appeal and refile, but we have to figure out how to not make it so confusing that, you know, nobody does anything with what you filed. But you don't want to happen. Passing the buck. Next slide, please. So I just wanted to flag for you that I'm seeing a bunch of you reporting that local offices where VAWAs have to adjust are completely clueless about the law and about the context of domestic violence. The good news is that we seem to actually still be able to at least send problems to headquarters, and they seem to magically be able to do some work with local offices. There's also a really old memo, I think it's from like 2000 or 1998 or something like that, which is 8 pages long, and the last couple pages are telling local offices what they're supposed to do with VAWA cases. And it's worth, you know, pulling those out, downloading them, printing them out, and taking them to your local offices. And also, I think it's worth doing what we did 20 years ago, which is ask you all to work with your domestic and sexual assault providers locally, ask for meetings with the local office and kind of talk to them about the problems. And that you would be happy, or your DV people would be happy to train them on domestic violence issues. Now, Laura discovered an interesting option for self-petition denials. I mean, we know that people go to the AAO because we've been doing it on like these good faith marriage, but I don't think anyone's tried this board option. You want to tell us a little bit about that, Laura?
So the I-360 can be appealed to the BIA rather than going to the AAO. And sometimes that's just a better option because especially if you're making very legal, technical arguments, sometimes the BIA just gets it more than the AAO will, especially if you go and look at AAO unpublished decisions and your particular legal argument or arguments that you're going to be making have been, you know, AAO hasn't gotten it, or they've been adjudicating it against your client's interest. So you can file with the BIA. There's the particular form, ERI 29. Always check, like everything else, always check the instructions. This form, even though it's going to the BIA, it actually gets filed with the USCIS office that issued the decision. So in this case, with Vermont Service Center, and the fee as well. And there is, for this form, there's also the possibility of a fee waiver. So we just found it interesting too that the form was filed not with the BIA directly, but with BSC, and it's probably because they're feeing in, which they do sometimes for other EOIR cases. But BSC just fees it in, accepts it, and then sends it over to the BIA.
Okay, we ready to move on? Okay.
Yes, sorry, I was in the middle of it.
So this is, we've only got a few minutes left. So these are basically what we're telling you is what we're working on. We all know the NTA memo is a problem. We're in the middle of doing responses to it, coming up with creative ideas on how to challenge it. This is definitely something we're interested in litigating. So let us know if you are interested in that. Next slide, please. The only good news, and actually we're in the midst of writing up practice pointers, which include these ideas about litigation, based on the stakeholder notes, and we're finishing them. They're kind of a monster, but that should be out right after Thanksgiving. So the only good news on this is they do seem to be saying that, unlike some of these other situations where they said your case dies basically even when you have a motion pending, like work authorization, I think is a problem. They will not issue an NTA if you have filed a motion. They definitely won't issue an NTA if you filed an appeal. So this all goes to, we're all going to have to start doing motions. We're all going to have to start doing appeals. And I think we're all going to have to start learning how to practice in removal in federal court, unfortunately. One of this discretion is one of the things we're exploring on what we can argue about discretion and prosecutorial discretion in the survivor context. These are some existing materials, and as I mentioned, the practice pointers are about to come out. Next slide, please.
And I do want to just point out to everybody, because I'm seeing a couple of questions about this. Any of the memos that we've mentioned, any of the, hey, look at our amicus brief on this, those are all in today's materials that you should have gotten. If for some reason you didn't get it, let us know.
Yeah, and I mentioned some that I just thought of that probably aren't in there, but they are on our website.
Yeah, they're on our website, or you can always email us.
Later, yeah. So and we know it's hard to find stuff on our website. We're actually about to set up a new website. So this is a plea and a invocation to all of you: is we need to add these new skills to our social change repertoire. And we're all learning how to do it, and we're all trying to teach you how to do it, and we're bringing in experienced litigators to help us do that and working with them. So we want to litigate, and we want to do FOIAs, and we want to do kind of strategic, like organizing type litigation. So it's not just like one lawsuit. We want to try different kinds of lawsuits in different venues, arguing different things. Kind of the goal here is to get them to change what they're doing, not necessarily to win a case, right? We want to get them to change what they're doing. The one that we've advanced so far is this bona fide work authorization, which is really a delay case. They have never, and they've actually literally refused essentially to implement a law that we got Congress to pass in 2005 that says they may issue bona fide work authorizations. And we know that there were internal discussions about this where some people at CIS were saying, yes, you do bona fide, then you do waitlist, then you do the U visa. So what we're working on, there was a case where the judge basically said, I don't believe what you're saying, CIS, and I'm ordering discovery. And CIS's response was to moot the case out by granting work authorization. So now we're thinking a simultaneous class action, but another group filing first, and also some FOIAs to find, and either through discovery or FOIA, kind of get more transparency on the decision-making process not to implement the law. So let us know if there are other issues. I mean, if you're going to tell us you want us to litigate something, then you're also going to have to help us find the resources for it. But again, you don't have to know how to do this. A lot of experienced litigators have said they're willing to be part of a mentorship system. We have a new litigation listserv, which has experienced litigators and new people sharing arguments and strategizing together. And I'm the person you should contact if you want to get involved in this effort, because I'm trying to figure out how to hire someone to help us do this. And so, but for now, I'm in charge of it, working with the rest of the staff. Okay, let's do are you thankful, Floresista, with all our beautiful faces? And so Me at the top, to my right is Amy Chung, who is our OVW person. Down over on the furthest right, Laura, I think this is an old hairdo for you. With the leaves above it.
That's just my high maintenance hairdo.
That's the rainy day hairdo. To her left is Maria, and below me is Cecilia, and over on the farthest left is Alam. So now you know what we all look like. And the final slide is how you can get a hold of us. And we managed to come in under 4 o'clock. Yay! So thank you all. This will be recorded. We're actually going to start applying for CLE credit. We're going to try to get Texas CLE credit, and then you can use that in other states.
And while you're talking about that, answer that quick survey, please. See that 3-question survey link? It asks you 3 short questions about today's webinar, and the CLE just reminded me of it because one of those questions is about that.
And we'll send that out again afterwards. But again, if you're thankful for our help, we'd really appreciate a donation. Thanks
Thank you, everybody.
Bye-bye.
Happy Thanksgiving.